Mes collègues de l'Académie, Monsieur Mohamed Ahmed Ben Abdallah, Monsieur Abdallah Lahrami, chers messieurs, c'est un grand honneur et une joie immense d'être avec vous aujourd'hui et de faire mon discours d'inauguration. Je suis vraiment très émue par vos mots. Merci beaucoup. C'est avec toute modestie que je commence à être membre de cette académie. C'est vraiment une très grande joie. Mon intervention, je vais faire en anglais. J'espère que je vais être bien compris. And it's about justice after war, what international law can do and cannot achieve. Dear colleagues, hope can be codified in treaties. We all share the hope of living a peaceful life, free from suffering of war, death, and destruction. After World War II, this hope was enshrined in the UN Charter, the famous Article 2, Paragraph 4, I quote, "All members shall refrain in their international relations from the threat of use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations." A whole system of legal barriers was erected to enforce this prohibition, especially in Chapter 7 of the Charter. However, the Charter did not grant the authority to resolve all emerging conflicts and stop violence in international relations to a court with an authoritative voice. A court was foreseen in the Charter, the International Court of Justice in The Hague, the successor to the Permanent Court of International Justice. But its doors are, as a rule, not automatically open for the opponents in military conflicts. On the contrary, the process for accessing it is complicated. States must explicitly accept jurisdiction, be it in general or in relation to the specific conflict, a restrictive regulation that reflects the concept of state sovereignty. Without consent of the states concerned, the court is not allowed to decide. Nevertheless, victims of conflicts, usually the weaker parties, whether states or individuals, desperately try to find a judicial forum for their complaints. This leads to interesting attempts to gain access to courts through back doors, for example, by invoking quasi-universally ratified treaties such as the Genocide Convention or Human Rights Conventions. Is there a problem? So I should wait. Thus, this is how the European Court of Human Rights also comes into play as a court whose jurisdiction is limited to Europe, but who had at its peak 47 members, including Russia. Thus, in recent years, we could witness several attempts to bring wars before courts and to try to stop them, but all have been in vain. For example, the war broke out between Georgia and Russia in August 2008. Georgia turned to the International Court of Justice, citing the International Convention on the Elimination of All Forms of Racial Discrimination. It argued that the arbitrary killing of Georgian citizens because of their ethnicity violated the convention. The International Court of Justice adopted a vaguely worded injunction ordering both Russia and Georgia, I quote, to refrain from any act of racial discrimination against persons, groups of persons, or institutions, and to do all in their power whenever and wherever possible to ensure, without distinction as to national or ethnic origin, the security of person. But this order was to no avail. The war continued. The same scenario was repeated during the Russian invasion of Ukraine in 2022. Once again, the International Court of Justice ordered interim measures, but the tanks did not stop. In their despair, both Georgia and Ukraine turned to the European Court of Human Rights and based their complaints on human rights violations. The Strasbourg court reacted as well, but the result was the same. The voice was not heard. And we all remember that the International Court of Justice, based on a complaint of South Africa against Israel, adopted 3 decisions on interim measures on 26th of January 2024, on 28th March 2024, and on 24th May 2024, with concrete orders for Israel to stop its attacks endangering the civil population. There as well, the war continued as before. Therefore, even the most optimists must admit that law is not an effective means to stop wars once the tanks have crossed the border. In times of acute crisis, courts are powerless. Words no longer matter. But what about the end of wars? Can justice be done after the end of a military conflict, when the disastrous consequences are visible and the cry for justice is louder than ever? The historical example are the Nuremberg trials, just 80 years ago, where 24 Nazi war criminals were accused of conspiracy to commit crimes against peace, war crimes, and crimes against humanity. 10 of them were executed, 2 committed suicide, 7 were sentenced to long prison sentence, 1 was tried in absentia and sentenced to death, and 3 were acquitted. Similar trials were held in Japan. But then, for many years, there were no such examples anymore. It was only about half a century later, in the 1990s, that the idea of bringing wars to court was revived. The shockwaves caused by the genocidal wars in Rwanda and Yugoslavia led to the establishment of special courts, the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia. The civil war in Yugoslavia was also adjudicated by the International Court of Justice. And another important player entered the scene, the European Court of Human Rights, as it had by then developed a jurisprudence according to which human rights had to be safeguarded not only in times of peace, but also in times of war. At first sight, we may consider that this is a really progressive step in human civilization. But let us have a closer look and analyze what was really achieved in 3 different scenarios. I will present 3 different scenarios. The first is the Chechen War before the European Court of Human Rights. The second is the Bosnian War before the International Court of Justice. And the third is the Russian-Ukrainian War before the European Court of Human Rights, a judgment just a few months ago. The first Chechen War lasted from 1994 to 1996, and the second Chechen War from 1999 to 2009. While the outbreak of the first Chechen War delayed Russia's accession to the Council of Europe and the European Convention of Human Rights until 1998, the Second Chechen War was covered by the convention. Russia had ratified it and promised to safeguard the human rights enshrined in the convention, including the right to life, the prohibition of torture, and inhuman treatment. This promise had legal teeth. Those affected by the war could take their case to the Strasbourg court, the guardian of the convention. The first victim of war who found the way to the doors of the Strasbourg court was Metka Chuchueva Isayeva, an ordinary Chechen woman who had lost her 2 children and her daughter-in-law and was wounded herself severely in a Russian attack. According to the court's reconstruction of events, at the end of October 1999, the city of Grozny, the capital of Chechnya, and its suburbs were targets of wide-scale attacks. On 29 October 1999, Russian TV informed the refugees that a humanitarian corridor had been arranged for civilians to escape from the fighting in Grozny. The applicant and her family left Grozny on this humanitarian corridor, but were stopped by Russian military and told to return to Grozny. When the applicants turned around, together with thousands of others, all stuck in their cars, planes appeared on the sky and fired missiles, killing the relatives of Mrs. Isayeva and wounding herself. During the proceedings at the European Court of Human Rights, Russia defended these killings, arguing that Chechen fighters were among the civilians, making the killings military necessity. However, as Russia refused to hand over the relevant documents, the court was unable to verify this. Nevertheless, the court concluded that even assuming a legitimate purpose, the attack had not been planned or carried out with sufficient care to protect civilian lives. The military leadership must have been aware of the presence of civilians, but had failed to communicate adequately with the pilots and had not taken any protective measures. Ultimately, the court found that the fate of the civilians had not played any role in the decision to use force. Therefore, Russia was found guilty of violating the right to life and had to pay to this ordinary Chechen woman, Metka Chuchueva Isayeva, 25,000 euro for non-pecuniary damages. The very fact that such a case was debated before a European court in 2005 is sensational in itself. War, or rather the suffering of individuals during wars, was brought before a judicial body. This ordinary woman from Chechnya and was one of thousands of victims, and she was able to argue her rights in front of a European court. It ruled with 47, which is responsible for 47 countries. She won her case. The court ruled in her favor. Russia paid the compensation fixed by the court. This was in 2005. The Chechen War, nevertheless, continued for another 4 years. Metka Isayeva's case was one of hundreds of others that followed concerning killing, kidnappings, torture, disappearances, rape, and other war crimes. However, even if the small compensation, 25,000 euro, awarded by the court was paid, the Russian authorities failed to take additional steps to provide redress for victims. For example, they did not search for the missing people, for the disappeared people. They did not restore property. The war strategy did not change either. Protection of civilian lives was not improved. The execution procedure of the court's judgment is still ongoing now, today, even 3 years after Russia was expelled from the Council of Europe. Let me quote the last finding of the Committee of Ministers of the Council of Europe in 2024. I quote, "The first judgments in this group have been pending for 18 years, and the committee has so far examined the group at regular intervals during 45 meetings, having discussed the group in 3 separate thematic clusters and jointly and adopted 2 interim resolutions. During its previous examination in June 2022, the committee deplored once again the absence of any tangible progress in execution." The war was officially declared over in 2009. Perhaps it was one of the most judicialized wars of recent times because of the large number of cases brought before the Strasbourg court. But what is the real impact of human rights judgments on the perception of justice and injustice? For those who won their cases in Strasbourg, it certainly helped. But what are around 290 judgments on human rights violations in a war that cost around 100,000 lives? Not to count those who were wounded, displaced, or who have disappeared. It's a lot when we consider the complete impunity that reigns usually after wars. But is it enough? Does such jurisprudence have sustainable effects? Let us look at the second example, the war in Bosnia and Herzegovina between 1992 and 1995. The Bosnian War, which was also a religious war to a certain extent, was brought before many courts. The International Court, Criminal Court for the former Yugoslavia, adjudicated about 150 criminal cases, among them the cases of the most famous, or rather infamous, war criminals, Slobodan Milosevic, who died, however, before the end of the trial, Radovan Karadzic, the former president of Republika Srpska, and Ratko Mladic, the supreme commander of the Bosnian Serb army. The latter two were sentenced to lifelong sentences. While these trials were very important, other judgments had an even greater impact on the development of international law, such as the first judgment of the court in the Tadic case, which was the first determination of individual guilt in connection with serious violations of international humanitarian law by a truly international tribunal. But if we talk about judging wars, the procedures before the International Court of Justice are even more decisive, and they do not only focus on the criminal responsibility of certain individuals, but take a broader view on the war. Therefore, I will concentrate on the judgment of the International Court of Justice. The proceedings lasted for 14 years, from 1993 to 2007, making it one of the longest and most complex cases in the court's history. The outcome was a judgment that could truly be called historical, but was nevertheless very controversial. While in normal court cases, as a rule, one party wins and one party loses, resulting into one party being happy and the other unhappy, the International Court of Justice managed to disappoint both parties in this case. The case was originally lodged by Bosnia and Herzegovina against the Federal Republic of Yugoslavia. Due to the dissolution of the Federal Republic of Yugoslavia, the situation was complicated, as Bosnia and Herzegovina had itself been a part of Yugoslavia. What was known as the Federal Republic of Yugoslavia changed its name and composition several times. During the proceedings, Montenegro separated from Serbia. Ultimately, only Serbia remained as a respondent. Bosnia and Herzegovina accused Serbia of committing genocide on its territory. It argued that Serbia had supported, aided, planned, and financed the commission of genocide. It was responsible for the actions of the army of the Republika Srpska, either as its organ or as a force under its control. Thus, Bosnia and Herzegovina wanted to hold Serbia responsible for all the atrocities that had occurred on its territory during the war. However, the International Court of Justice did not take this approach. The court qualified only the murder of more than 8,000 men and boys in Srebrenica, famous to you all, I guess, as genocide, but refused to consider as genocide all the atrocities that occurred elsewhere in Bosnia. Furthermore, it did not find Serbia responsible for the Srebrenica massacre, as this had been committed by the army of Republika Srpska, not the Serbian army. In the court's view, Serbia did not exercise effective control over the army of Republika Srpska, nor did it commit, plan, or directly participate in the genocide. Compared to the accusation made, the findings of violations against Serbia were minor. It was criticized for being aware of the serious risk and having the capacity to influence events, yet failing to take all measures within its power to prevent genocide. This message is couched in legal terms and sounds like this, I quote, "From these it is clear that in respect of the massacres in Srebrenica in July 1995, the respondent failed to fulfill its obligations and in paragraph 59 of the order and reaffirmed in the order of 1993 to take all measures within its powers to prevent the commission of the crime of genocide." In the end, the International Court of Justice did not grant Bosnia and Herzegovina any compensation. It noted, I quote, "The court does not therefore find it appropriate to give effect to the applicant's request for an order for symbolic compensation in this respect." For the population of Bosnia and Herzegovina, this judgment was disastrous. While the events in Srebrenica were undoubtedly the most horrific aspect of the war, the victims could not accept that the other atrocities were classified only as war crimes and crimes against humanity for which the court was not competent under the Genocide Convention. Even if these legal subtleties were correct, they were seen as denying the truth and the suffering of hundreds of thousands of people. Even worse, this judgment was seen as a slap in the face of the victims. While the Serbs were not really happy with the court's finding that they had violated international obligations, they still celebrated the judgments on the streets of Banja Luka. Commentators on both sides criticized the judgment for not bringing peace to the Balkans, but making things worse. In reality, however, the case was not about the application of the law, but rather about the competition between different narratives on genocide and nationalism. Two Serbian lawyers rightly observed, neither of the parties before the court was that interested in presenting their best legal case, but in telling their story of the Bosnian War. The genocide case was therefore a true judicial drama, at the same time an exercise in storytelling and in legal argumentation. It was also a play within a play in which the actors in the courtroom were taking the cues from the larger political play taking place outside. And it was the actors in this larger play, the intellectuals and politicians, stoking the fires of nationalism as a vehicle for keeping or obtaining power, who first discovered a concept, a word that could easily manipulate to their own ends. This word was genocide. The war ended with the Dayton Agreement, which was reached through negotiations. This took place 30 years ago in 1995. However, the issues of justice and injustice, of guilt and responsibility have not become less urgent or emotional since then. I go there 6 times a year. I can tell you that's how it is. In fact, this question of justice is still present in today's Bosnia, hindering reconciliation and progress. Would the situation have been better without the court's judgment? I doubt it, but perhaps too much hope was linked to it so that it could not live up to the expectations. Court can only act within narrow and clearly defined boundaries. So let me come to my third case study, the war between Ukraine and Russia, a war that has, as we all know, not yet come to an end. Unlike in Bosnia and in Chechnya, the war between Russia and Ukraine is not a civil war, but a classical interstate war. There's no doubt that Russia has violated Article 2, Paragraph 4 of the UN Charter, the prohibition of the use of force, when it sent tanks over the Ukrainian border on 24th February 2022. In reality, however, the war had started long before with Russia's invasion of Crimea in 2014. Ukraine attempted to bring the violations of international law before the International Court of Justice. However, after initially succeeding in having an interim measures adopted, the ICJ declared the substance of the complaints inadmissible. The door remained open for Ukraine. The door that remained open for Ukraine was only the door of the European Court of Human Rights. Thousands of Ukrainian citizens, as well as Ukraine as a state, used it and brought complaints to Strasbourg. By now, we have a judgment handed down a few months ago on 9th July 2025, comprising several complaints related to the war. These include complaints about the events in Crimea and eastern Ukraine, the complaint of the Netherlands regarding the downing of flight MH17, and complaints about human rights violations during the first 6 months of the full-scale invasion. However, due to Russia's expulsion from the Council of Europe and the convention system, the court is no longer competent to adjudicate events after 16 September 2022. This means that while international human rights treaty cover the first 6 months of fighting, the rest, the present time, of this ongoing war is beyond the scope of judicial scrutiny. With 26 European states governments intervening in Strasbourg, the case presented itself as a case Europe versus Russia. Russia, however, did not participate in the proceedings. Although it had submitted memorials concerning admissibility question and argued in pending cases before 16 September 2022, it cut all communication lines after that date. The Russian judge, Mikhail Lobov, left the court permanently and was not replaced. Based on a broad interpretation of the relevant procedural rules, the court replaced the Russian judge with ad hoc judges from other countries. The main flaw in this procedure is, therefore, that it is one-sided. Russia's point of view was not represented, and consequently, Russia denied the legitimacy of the whole procedure. In its judgment, the court notes that Russia's last response dated back to 5th March 2022, when it asserted that Russian forces were not attacking civilians or civilian objects, but only military targets, and that the Russian Federation was taking, I quote, every measure to avoid civilian casualties and ensure full compliance with the convention. After this letter, the court did not receive any further response from the Russian Federation. However, it did not consider this as a reason to discontinue the proceedings. On the contrary, it held, I quote, in the absence of sufficient cause for the failure of the respondent government to submit a memorial or to participate in the hearing, the Grand Chamber decided to proceed with its examination of the case, being satisfied that such a course was consistent with the proper administration of justice. While the court judgment provides in 1,652 paragraphs, it's a very long judgment, a detailed account of human rights violation during the war, the most important part is the general historical assessment given right in the beginning. I quote, "The nature and scale of the violence, as well as the ominous statements concerning Ukraine's statehood, its independence, and its very right to exist, represent a threat to the peaceful coexistence that Europe has long taken for granted. As already explained, the dangerous rhetoric has also on occasion have been extended to encompass other Council of Europe member states, including Poland, Moldova, and the Baltic countries. These actions seek to undermine the very fabric of the democracy on which the Council of Europe and its member states are founded by their destruction of individual freedoms, their suppression of political liberties, and their blatant disregard for the rule of law. In none of the conflicts previously before the court, there has been such near universal condemnation of the flagrant disregard by the respondent state for the foundations of the international legal order established after the Second World War, and such clear measures taken by the Council of Europe to sanction the respondent state's disrespect for the fundamental values of the Council of Europe. Peace, as already underlined, but no less importantly, human life, human dignity, and the individual rights guaranteed by the Convention." End of quotation. Thus, in this case, we have what was missing from the others, a clear and general pronouncement on guilt and responsibility. This makes the case unique. Unlike in the Bosnian case, it is clear who was right and who was wrong, and who won and who lost the case. But is the result better? The judgment could not change anything on the battlefield. The fighting that impacts the lives of civilians continues as before. Every day we can watch on TV. According to point 26 in the 28 points peace plan elaborated by the Trump administration, all parties involved in the conflict receive, according to their will, full amnesty for their actions during the war and agree not to assert any claims or consider any complaints in the future. This would, if this 28 points plan were to be implemented, this would wipe out immediately the effects of this long judgment. So, what is it worth? And with that, let me come to the concluding reflections on the role of courts in adjudicating wars. Let us acknowledge the obvious. Human justice is imperfect. It is also clear that international law has not yet reached the standard it aspires to. It could certainly improve. At the same time, however, we must acknowledge that if the glass is not full, it is not empty either. The Nuremberg and Tokyo trial set the example that has been followed since the 1990s, a time when we dreamed of the end of history and the universality of values such as democracy, human rights, and the rule of law, which would provide guidance not only in peacetime but also in war times. So, what are the lessons learned from the court's successes and failures in adjudicating wars? Let me summarize my findings and reflections in 10 theses. First thesis: justice matters, especially in the aftermath of a war. Justice has three perspectives: the perspective of the victims, the perspective of those responsible, and the perspective of the states involved. For victims, it is important to have an acknowledgement of their suffering and innocence, and if possible, to get compensation. Concerning those responsible, it is important to bring them to trial and to confront them with the atrocity they have committed, if possible, to sentence them to adequate criminal sentences. And for the states, it's important to clarify who is right and who is wrong, that is, whose position is supported by international law and whose position is incompatible with international law. Second thesis, money is only a secondary element in the quest for justice. It is clear that no sum of money whatsoever can compensate for having lost beloved relatives or for being expelled from where the family has been living for decades. But even if money cannot heal, the no to compensation is not a solution either. Third thesis, we should not underestimate the iconic function of a trial. You will all be familiar with the famous photographs of the Nuremberg trials in which the formerly powerful Nazi elite of the so-called Third Reich was seated in the dock, guarded by soldiers of the victorious powers. On the Ukrainian internet, there was a collage circulating with Putin and his inner circle taking the place of Göring and his associates. This turned the power dynamic on the head. The perpetrators become the weak and must listen to the voices of the victims they pretended to ignore. But only criminal trials have this effect. In proceedings on human rights or on state responsibility in Strasbourg and The Hague, there will be usually unknown state officials pleading for their governments. Although the oral hearings are important, they do not convey the pictures for long-term memories. Fourth thesis, although the law shapes judicial proceedings, the underlying messages are not legal. What is more important than legal assessment is the fact that court proceedings with their adversarial structures help to shape historical narratives for future generations. This is true when accounts of events are not contradicted, but also when historical truth is controversial. Different versions will then persist. Statements made during judicial proceedings will remain a point of reference for visions of the past. Fifth thesis, words matter. This is particularly true of legal terms such as genocide, war crime, crime against humanity, violation of the prohibition of torture. However, these are very broad categories. While they can help to classify and judge, they can also obscure important details needed to understand the real story. Not all rapes, not all murders are the same. For those who have suffered, it is the real story behind these notions that counts. It should not be forgotten. Law and literature, be it biographies, novels, poems, journalistic reports, are therefore necessary and complementary. Sixth thesis, judicial proceedings involving two opposing parties and neutral judges provide the best setting for resolving disputes about past events. Therefore, trials that are incomplete because one side misses, like Russia now, are as a rule inadequate. Seventh thesis, there is a general consensus that in order to deliver a fair judgment, judges must act within their competences and base their findings on pre-existing norms. However, this inevitably leads to complex legal debates on jurisdiction and case law that victims neither understand nor appreciate. It's difficult to bridge the gap between law and emotion. Therefore, good management of expectations is essential. Everybody involved should know what law can achieve and what it cannot achieve. Eighth thesis, arguing about guilt and reparations can hinder the achievement of peace, as demonstrated by the American proposal for a quick peace deal that excludes any form of responsibility. However, honesty can also be the first step towards achieving lasting peace. This is preferable to short-term peace deals that do not solve the underlying problems. Ninth thesis, when adjudicating wars, time is a crucial factor. Rushed proceedings will not be helpful. However, if they last for decades, justice will not be seen to be done. 10th thesis, if the crimes committed during wars are not punished, the credibility and legitimacy of the law is generally undermined. Why should a thief who stole a ring be sentenced when nobody is held responsible, when the civil population of whole villages is wiped out? So, to conclude, we can say that even imperfect justice in wartime is better than no justice at all. A culture of impunity destroys the delicate fabric of human society. However, we still have a long way to go before we have an international legal system that enables us to reach satisfactory conclusions when adjudicating wars. I thank you for your attention.